Okay, do you know who you are? That's what we're going to be talking today. This is a quote by Cicero. Power and law are not synonymous. In truth, they are frequently in opposition and irreconcilable. There is God's law, from which all equitable laws of man emerge, and by which men must live if they are not to die in oppression, chaos, and despair. Divorce from God's eternal and immutable law, established before the founding of the suns, man's power is evil, no matter the noble words with which it is employed or the motives urged when enforcing it. Men of good will, mindful therefore of the law laid down by God, will oppose governments whose rule is by men. If they wish to survive as a nation, they will destroy the government which attempts to adjudicate by the whim of venal judges. And boy, I'll tell you, they ought to do something today. Anyways, the greatest weapon of the oppressor is the mind of the oppressed. Everything is an illusion. We're in the matrix. So where does sovereignty come from? We're going to be talking about sovereignty today. Do you know who you are? Sovereignty exists because of common law. The people of all common law, all the countries with the common law of England owe their sovereignty to the common law, and Canada, United States, Australia, New Zealand, and all common law countries in the world, the people are the sovereignty. The representation on common law covers the subject more thoroughly. Do you know who you are? We're going to talk about what is a sovereign, who is a sovereign, where does sovereignty come from, rights and duties of sovereignty is covered by the common law presentation, and how you can lose your sovereignty in the color of law presentation. And there's actually two classes of citizens, and we're going to talk about that too. And how do you regain your sovereignty is covered in the Asserting Sovereignty presentation. So, sovereignty is the right to rule. Sovereign can be a king or queen. Sovereign can be a group of people. Sovereign can also be a living soul. This is an English court case. Sovereign, a chief ruler with supreme power, a king or other ruler with limited power, and action is not maintainable against a foreign sovereign. U.S. Supreme Court, sovereignty is the right to govern. Nation or state sovereign is the person or persons in whom that resides. For the very idea that one may be compelled to hold his life or the means of living or any material right essential to the enjoyment of life at the mere will of another seems to be intolerable in any free country where freedom prevails as being the essence of slavery itself. U.S. Supreme Court. In the common law country, the sovereigns are the people. Common law is everywhere. That's what the courts have said. Even in countries where there's Roman civil law has common law, believe it or not. And actually, if you go back before the Roman civil law, common law was there. Dred Scott versus Sanford. The words people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our republican institutions, form the sovereignty and hold the power and conduct the government through their representatives. They are what we familiarly call the sovereign people, and every citizen is one of those people and a constituent member of the sovereignty. And this is not unique to the United States. Canada as well. Okay, this is a Canadian court case. This is referenced Casaloma. Casaloma's in Toronto. The sovereign people, through their representatives, have created the court and the board as well as the municipal council and defined the rights and duties of each. This is the Lord Nelson Hotel case. The Parliament of Canada and the legislatures of the several provinces are sovereign within their spheres defined by the British North America Act, but none of them has the unlimited capacity of the individual. And this is Australian case. Translated into constitutional terms, it denotes that the sovereign power which resides in the people is exercised on their behalf by their representatives. Another Australian case. The powers of the government in this country are derived from the people who are the ultimate sovereign. Another English case. Every individual was sovereign over himself. So we the people are literally kings and queens, okay? The people or sovereign are not bound by general words and statutes restrictive of prerogative right, title, or interest unless expressly named. Acts of limitation do not bind the king or the people. The people have been ceded all the rights of the king, the former sovereign. That's a New York court case. Another court case, Lansing versus Smith. The people of this state, as successors of its foreign sovereign, are entitled to all the rights which formerly belonged to the king by his prerogative. Through the medium of their legislature, they may exercise all the powers which previous to the Revolution could have been exercised either by the king alone or by him in conjunction with his parliament, subject only to those restrictions which have been imposed by the Constitution of this state or in the U.S. And that's a 1829 court case. So at the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects, and have none to govern but themselves. The citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. And that's U.S. Supreme Court. Another court case. Their people of a state are entitled to all the rights which formerly belong to the king by his prerogative. U.S. Supreme Court, it will be admitted on all hands that with the exception of the powers granted to the states, the federal government through the constitutions, the people of the several states are unconditionally sovereign within their respective states. Jacobite New Law Dictionary. Okay, so this is even in England back in 1750. Citizens of London are either freemen or such as reside and keep a family in the city, and some are citizens and freemen and some are not, who have not so great privileges as others. The citizen of London may prescribe against a statute because their liberties are reinforced by statute. So what they're essentially saying, think about it, in my other court presentations or videos, I talk about how a judge, when a statute's involved and he walks away from being a judge and now he's a clerk working for the prosecutor, and so what happens is they're talking about here the citizen may prescribe against a statute. Okay, the statutes don't apply to we the people. That's really what it comes down to. And there's more court cases that talk about this. Governments are but trustees acting under derived authority and have no power to delegate what is not delegated to them. But the people, as the original fountain, might take away what they have delegated and entrust to whom they please. The sovereignty in every state resides in the people of the state. They may alter and change their form of government at their own pleasure. U.S. Supreme Court again. And so think about it. First of all, the government's a trust. The Constitution is a trust indenture. It creates a trust. And so if you watch my bankrupt corporate so-called governments video, you'll see that they've gone and created these corporations. Well, that's not the trust that's created. That's a separate entity. So there's two entities, and they're playing these games. And so first of all, governments are trusts, and they only have delegated authority, okay? And so think about it. Do I have the authority to delegate to tell you to go and take the neighbor's property and give it to some other guy because he doesn't have any or something? Absolutely not. And so, again, we got to understand the meaning of these words, okay? And so the only power the government has is power that's delegated, and it's a trust. And there's more court cases that talk about this. This is Yickwo versus Hopkins. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, all sovereign powers are delegated to the agencies of government. Sovereignty itself remains with the people, by whom and for whom all government exists and acts. So therefore, the only power held by the government is what we, the people, delegated, and we are not competent to delegate authority to Congress to turn around and pass a law that says that we have to pay taxes, that we have to follow some speed limit, that we have to do anything. Okay, so none of those statutes apply to we the people, and so this is what you have to understand: is that I don't have authority to tell Congress to do anything to you, and so Congress doesn't have the authority. Neither does any state legislature. This is another U.S. Supreme Court case. There is no such thing as the power of inherent sovereignty in the government of the United States. In this country, sovereignty resides in the people, and Congress can exercise no power by which they have not, by their Constitution, entrusted to it. All else is withheld, okay? So they don't have the authority. And that's the bottom line. A lawful de jure government is a trust. The Constitution is a trust indenture. A trust indenture is a contract. A corporation is not a trust. There's no authority in any Constitution for a corporation. This is Title 28 United States Code, Section 3002, and there's no delegation of authority, no delegated authority for a corporation called United States or any agency, department, commission, board, or other entity of such a corporation. And what they're saying here is, as used in this chapter, United States means a federal corporation, agency, department, commission, board, or other entity of the United States, or instrumentality of the United States. Well, think about it. All banks are instrumentalities. Agency, that sounds like Federal Bureau of Investigation, or how about the Central Intelligence Agency, or the Federal Aviation Administration, or the Department of Homeland Security, or the Secret Service. These are all agencies of this corporation. And so if you're going to sue, what this is Title 28 is judiciary. And so therefore, if you're going to sue, this is what they see. This is who you're suing. That's the only thing you can sue. And so, again, that's what they're talking about. And so it's a corporation. The same thing in Canada. This is the word Canada is used in Section 91(1) of the Constitution Act. Does not refer to Canada as a geographical unit, but refers to the juristic federal unit, and a juristic federal unit's a corporation. Now, Dred Scott versus Sanford, but in considering the question before us, it must be borne in mind that there is no law of nations standing between the people of the United States and their government and interfering with their relation to each other. The power of the government and the rights of the citizens under it are positive and practical regulations plainly written down. The people of the United States have delegated to it certain enumerated powers and forbidden it to exercise others. Okay, so when they went and signed on to the UN treaty and they went and brought in Unidroit and this UN law merchant and all that stuff, okay, that has nothing to do with we the people, okay? It cannot. They don't have authority to make that have anything to do with we the people. That's why they have to fabricate evidence of some fictitious entity. Spooner versus McDonnell. The sovereignty of a state does not reside in the persons who fill the different departments of its government, but in the people from whom the government emanated, and they may change it at their discretion. Sovereignty then in this country abides with the constituency and not with the agent. And this remark is true both in reference to federal and state governments. A delegate cannot delegate. An agent cannot delegate his functions to a subagent without the knowledge or consent of the principal. The person to whom an office or duty is delegated cannot lawfully devolve the duty on another unless he be expressly authorized to do so. Okay, in other words, it's got to be in the Constitution, and there's nothing in the Constitution that talks about the Federal Bureau of Investigation or the Office of Attorney General or the Texas Department of Public Safety, okay, and this is a maxim of law, and so therefore they don't have a shred of authority. A delegated power cannot be again delegated. Another maxim of law. A deputy cannot have or appoint a deputy. Another maxim of law. Can I delegate to you the power to go to the neighbor and take his property and give it to the guy down the street because he is hungry? Can I delegate to you the power to tell some guy that he has to move his wrecked car or you are going to take his property? Can I delegate to you the power to stop and people and interrogate them and harass them because they're not following some rules that were made up this morning, like speeding? If I cannot delegate that power, then the government does not have that power. It is true that at common law, the duty of the Attorney General is to represent the king, he being the embodiment of the state, but under the democratic form of government now prevailing, the people are king, so the Attorney General's duties are to that sovereign rather than to the machinery of government. And that's Hancock versus that's a Kentucky court case, and again, this is proof that a holder has perjured his oath by going out and saying that these sovereign citizens are terrorists, okay, and that's a deliberate attempt to intimidate people and threaten people and facilitate their murder, because you know that the hired thugs are going to go out and murder people because of it, and that's all deliberate and calculated by Holder. Caha versus United States. This is Supreme Court again. The law of Congress do not extend into the territorial limits of the state, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government. Okay. And the exclusive jurisdiction of the United States, having forts and dockyards ceded to them, is derived from the express assent of the states by whom the cessions are made. It could be derived in no other manner, because without it, the authority of the state would be supreme and exclusive therein. Okay, and that's U.S. Supreme Court. Both of these are U.S. Supreme Court cases. And so I can tell you that there is no cessions, there is nothing ceded to the United States and Texas. And so when those U.S. border pigs assaulted me in West Texas, out there about 100 miles from El Paso, at their way station that they have out there, they perjured their oath. And Clements, or no, is it Clements or Cunningham, the judicial, or they should say the clerk masquerading as a judicial whore in the Northern District of Texas, perjured his oath when he dismissed the case. And so, and that's coming in fire the judicial whores in Texas, and fire the United States whores. Actually, it'll probably be more like fire the clerks masquerading as judges. Anyways, so it ain't over, Clements, and or Cummings, whatever your name is. And so anyways, U.S. Declaration of Independence, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. The Magna Carta is called the Great Charter of English Liberty. The Canadian Handbook for Judges cites the Magna Carta on page 77. Magna Carta says will not deny or defer to any man either justice or right. Actually, it doesn't say that. It says something similar to that, but these whores don't want you to know what it really says. The Magna Carta is not a unilateral act emanating solely from the spontaneous will of the king, as the charters of the predecessors of John. Neither is it a treaty, for we cannot say it was concluded between two legitimate and independent sovereignties, nor between two nations, nor is it a law. The barons do not appear in it as subjects, for they are freed from their promise of fidelity, and the king, brought captive, placed before them, submitted to the conditions which the conquerors imposed upon him. Magna Carta is therefore a contract, but resembles a treaty concluded between two nations, in that one of the parties, in virtue of the law of war, can impose its will upon the other. And that's Perlman versus Pichet, a habeas corpus court case in Quebec. So when anybody tells you there's no common law in Quebec, BS. So what they're essentially saying here is that the barons basically stuck a sword to the tyrant John's throat and said, "Here, king, we want you to sign this, or we'll run you through right now." And so that's essentially what happened. And so the queen, or I should say the bitch, and the president has the oath of office. We the people owe no allegiance to the bitch or the president. The bitch or the president owes allegiance to the people. And so which the bitch likes to perjure, so does Obama. So why do we the people set up governments in the first place? Think about it. We set up governments for protection against foreign enemies, protection from each other, to administer disputes in a fair and impartial manner. And the only legitimate function for government is to protect the rights of the people. That's it, nothing else. So you have a hierarchy. You have God, who's King of Kings, created we the people, and we the people created the government. And if you think about it, I mean, the courts have said that we the people are kings, right? So God is King of Kings, and we the people created the government, and the government created corporations. And if the government's talking to you, it's because they think that you're a corporation. That's exactly what's going on. And so our rights, why is God in the Constitution? Think about it. Why is God in the Constitution? In the preamble to the U.S. Declaration of Independence, or in the preamble to the Constitution, it talks about ordain. We do ordain this Constitution. Okay, that's a Christian religious ceremony. Our rights, the reason God is in the Constitution, because our rights come from God. And if our rights come from God, only God can take them away. And the communists, like the NDP party up in Canada, like to every once in a while, they put out, well, we want to take God out of the Constitution. And, of course, the communists would want to do that. And that's what the agenda is. This is a U.S. court case. A citizen of of one state is a citizen of every other state in the Union. This is Hale versus Hinkle, U.S. Supreme Court. The individual may stand upon his constitutional rights as a citizen. He's entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation so far as it may tend to incriminate him. He owes no such duty to the state, since he receives nothing therefrom beyond the protection of his life, liberty, and property. His rights are such as existed by the law of the land, long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself and the immunity of himself and his property from arrest and seizure, except under a judicial warrant, a warrant of the law. He owes nothing to the public as long as he does not trespass upon their rights. And that's U.S. Supreme Court again. And a bench warrant is not a judicial warrant. These whores, like in Fort Worth and this whore Redmond in Lethbridge that issued his warrant, that was not a lawful warrant. That was not a judicial warrant. And Judgment Day is coming, whores. All so-called judges operate under a statute, and they are not judges, but they are clerks working for the prosecutor, as found in the de facto courts video and the Fire of the United Nations Whores in Canada video, and the Corruption in the Courts 3 video, and the Corruption in the Courts 4 video, and the J.D. Rook, the bought and paid for clerk masquerading as a judge video, and the upcoming Fire of the United Nations Judicial Whores in Texas video, and in other ones. There's no lawful warrants. Well, I should say when it's from these whores. there are at least two major classes of citizens, state and federal. This is the U.S. Supreme Court. There is in our political system a government in each of the several states, and the government of the United States is distinct from the other and has citizens of its own. One may be a citizen of a state and yet not a citizen of the United States. Did you know that? And that's McDonald versus State. There is a clear distinction between national citizenship and state citizenship, U.S. Supreme Court. Instead, this provision protects only those rights peculiar to being a citizen of the federal government. It does not protect those rights which relate to state citizenship. And that's 1993, Jones versus Temmer. Citizenship of the United States does not entitle citizens to privileges and immunities as citizens of the state, since privileges of one are not the same as the other. That's Tashiro versus Jordan. Maxwell versus Dow. The privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. Did you know that? A U.S. citizen doesn't have the access to the first 8 amendments against the powers of the federal government. The only absolute and unqualified right of a U.S. citizen is to residence within the territorial boundaries of the United States. A U.S. citizen is literally a slave. It's a piece of property. Such construction ignores the rights of a state in virtue of its sovereignty to confer citizenship within its own limits, where the rights incident to such a status are not of the citizenship mentioned in the federal Constitution. It does not follow that because one has all the rights and privileges of a citizen of a state, he must be a citizen of the United States. Since a distinction has long been recognized, such a distinction has long been recognized in this county. And that's a reference that's referring Dred Scott versus Sanford, which is a U.S. Supreme Court case, and that is actually taken from a Mississippi court case. The rights of the original judicial citizens of the states as such are not under consideration in the 14th Amendment. They stand as they did before the 14th Amendment and are fully guaranteed by other provisions. And that's U.S. Supreme Court again. Actually, no, that's U.S. versus Anthony before it went to the Supreme Court. Civil rights under the 14th Amendment are for federal citizens and not state citizens. Federal citizens as parents have no right to the custody of their infant children except subject to the paramount right of the state. So, citizenship in Canada is the same thing. It exists in Canada. The Charter adopted in 1982 refers to citizens of Canada several times. The courts have told us that laws of Canada are federal laws. Citizens of Canada are federal citizens. Canadians include state, which is the provincial citizens, and federal citizens. And this is the Charter. It says every citizen of Canada, Section 3. And in Section 6.1, it talks about every citizen of Canada. And 6.2, and 23.1, and 23.2, and 23.3. And in Section 3, it says every citizen of Canada has the right to vote in the election of members of the House of Commons. So what that's saying is elections are commercial elections. And Section 28 says, notwithstanding anything in this Charter, the rights and freedoms referred to it are guaranteed equally to male and female persons. Okay, so a citizen of Canada is a person, is a fictitious entity. And this is a California court case. It is evidence that they, U.S. citizens or citizens of Canada, have not political rights which are vested in citizens of the states. They are not constituents of any community which is vested in any sovereign power of the government. Their position partakes more of a character of subjects than of citizens. They are subject to the law of the United States or Canada as applicable, but have no voice in its management. If they are allowed to make laws, the validity of these laws is derived from the sanction of a government in which they are not represented. Mere citizenship they may have, but the political rights of citizens they cannot enjoy. And so we'll go into this a little bit more. A subject or national may indicate being a member of the sovereign state, especially one owing allegiance or democratic forms and usages. Owing an allegiance, sharing individual political rights, subject may imply a state of subjection to a person such as a monarch. A national is a more general word, may apply to anyone owing permanent allegiance to a nation, and indicates one belonging to a broad category that includes both people who are citizens or subjects, but also people who have not attained such legal status. Okay, so again, a citizen or a subject is basically a citizen a subject can be a citizen, but not necessarily. And a national is someone that's not a citizen or a subject. And so that's Merriam's third new international dictionary, 1986. A subject, Black's Law Dictionary, one that owes allegiance to a sovereign is governed by laws. The natives of Great Britain are subjects to the British government. Men in free government are subjects as well as citizens. As citizens enjoy rights and franchises. As subjects they are bound to obey the laws. The term is little used in countries enjoying a republican form of government. That tells me that the U.S. is no longer a republic. Proud versus Gore. This, in our opinion, it was not the intent of the legislature to restrict the operation of the statute to those who were only who were subjects of the United States government, and to exclude therefrom unnaturalized residents of foreign birth, whether black or white. And that's 1922. And so, again, they're talking about subjects of the United States government. U.S. versus Anthony. The 13th, 14th, and 15th Amendments were designed mainly for the protection of the newly emancipated Negroes. Okay, so again, the 13th, 14th, and 15th Amendment are for U.S. citizens. Downs versus Bidwell. U.S. Supreme Court. On the other hand, the 14th Amendment, upon the subject of citizenship, declares only that all persons born or naturalized in the United States and subject to the jurisdiction of thereof are citizens of the United States and of the state wherein they reside. Here there is the limitation to persons born or naturalized in the United States, which is not extended to persons born in any place subject to their jurisdiction. And so there's a difference. They're differentiating there. The persons declared to be citizens are all persons born or naturalized in the United States and subject to the jurisdiction thereof. The evident meaning of these last words is not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject. And that's Elk versus Wilkins. U.S. Supreme Court case again. The term citizen in the United States is analogous to the term subject in the common law. Okay, so this is all common law, really, if you think about it. And so back before the Civil War, they were called subjects, and then after the Civil War, after the 14th Amendment, they became citizens. Citizenship is a term of municipal law. Citizenship carries with it the idea of connection or identification with the state and a participation in its functions, and as such implies much more than residence. And so therefore, U.S. citizens can murder their unborn children. The unborn are not included within the definition of person as used in the 14th Amendment. And this is Colgate versus Harvey, U.S. Supreme Court. And while the 14th Amendment does not create a national citizenship, it has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship. In other words, they criminally converted citizenship into the opposite of what they intended, what the Founding Fathers intended. Citizenship is a political status and may be defined and privilege limited by Congress. Yes, U.S. citizens can. The term resident and citizen of the United States is distinguished from a citizen of one of the several states in that the former is a special class of citizen created by Congress. Okay? In other words, prior to the 14th Amendment, U.S. citizen did not exist. Bowling versus Commonwealth. The 14th Amendment referred to slavery, common law, consequently the only persons embraced by its provisions and for which Congress was authorized to legislate in the manner were those then in slavery. And then Van Valkenburg versus Brown. No white person born within the limits of the United States and subject to their jurisdiction or born without those limits and subsequently naturalized under their laws owes a status of citizenship to the recent amendments of the federal Constitution. And they're talking about 14th, 15th Amendments, 13th. And this is in the United States Code right now. Go look it up. Title 42, United States Code, Section 1982. It says all citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. And so that's right there, right now. Therefore, U.S. citizens residing in one of the states of the Union are classified as property and franchises of the federal government as an individual entity. A U.S. citizen, that's U.S. Supreme Court, a U.S. citizen upon leaving the District of Columbia becomes involved in interstate commerce and as a resident does not have the common law right to travel of a citizen of one of the several states. And after the adoption of the 14th Amendment, a bill which became the first Civil Rights Act was introduced in the 39th Congress, the major purpose of which was to secure to the recently freed Negroes all the civil rights secured to the white men. None other than citizens of the United States were within the provisions of the Act, and that's U.S. Supreme Court again. A subject, one who owes allegiance to a sovereign and is governed by by that sovereign's laws. Speaking generally, we may say that the terms subject and citizens are synonymous. Subject and citizens are alike those whose relation to the state is personal and not merely territorial. permanent and not merely temporary. This equivalent, however, is not absolute, for in the first place, the term subject is commonly limited to monarchical forms of government, while the term citizen is more especially applicable in the case of republics. And that's Black's Law Dictionary, 8th edition. Finally, it is to be noticed that the term subject is capable of a different and wider application, which includes all members of the body politic, whether they're citizens or resident aliens. All such persons are subjects, all being subject to the power of the state and to its jurisdiction, as owing to it at least temporarily fidelity and obedience. Black's Law Dictionary, 8th edition. Residents, this is taken from Vattel, okay, and this explains it very well. Residents, as distinguished from citizens, are aliens who are permitted to take up a permanent abode in the country, being bound to society by reason of their dwelling in it. They are subject to its laws so long as they remain there, and being protected by it, they must defend it, although they do not enjoy all the rights of citizens. They only have certain privileges which the law or custom gives them. Permanent residents are those who have been given the right of perpetual residence. They are a sort of citizen of a less privileged character and are subject to the society without enjoying all its advantages. Their children succeed to their status, for the right of perpetual residence given them by the state passes to their children. So, again, the Law of Nations is taken from the Law of Nations by Vattel, Book 1, Chapter 19, Section 13, page 87. And so, again, that's what a resident is, okay? And so that's what a U.S. citizen is. One does not necessarily become a non-resident, absconding or absenting himself from his place of abode. And so it's all in what you tell them. Residence, the fact of being officially president, the statutory president of incumbent in a benefice. That's Funk and Wagnall's dictionary. It might be correctly said that there was no such thing as a citizen of the United States. A citizen of any one of the states of the Union is held to be and called a citizen of the United States, although technically and abstractly there is no such thing. Every taxpayer is assessed a K trust. Having sufficient interest in preventing the abusement of the trust must be recognized in the field of the court's prerogative jurisdiction. So a U.S. citizen's a fictitious entity is what it is, okay? And so this has absolutely nothing to do with race, really. Taxpayers are not state citizens. This is in Southern Reports. Slater's protestation to the effect that he derives no benefit from the United States government have no bearing on his legal obligation to pay income taxes. Unless the defendant can establish that he's not a citizen of the United States, the IRS possesses authority to attempt to determine his federal tax liability. And that's the U.S. District Court in Delaware. When you're traveling, and then there's the U.S. border pigs. When you're traveling across the border, you tell the U.S. border pigs that you're a state citizen, and they say, we don't recognize state citizenship. How can you spell treason? The U.S. border pigs are deliberately and calculatedly engaged in treason by making that statement. The U.S. border pigs are under the direction and supervision of Holder, the bar member whore, and his hired thugs in the Office of Attorney General Corporation. And the Canada border pigs are too stupid to know anything about the two classes of citizens. The Canada border pigs are under direction of bar members like the bar member pig McKay and the bar member pig Nicholson and the pig Harper and the pig Tays and the pig bar member Johnston, who was the Governor General. He's another bar member pig. And the ultimate responsible is with Elizabeth the bitch. No disrespect to dogs intended. You know, a dog doesn't sit there and make you think he's your friend and stick a knife in your back like Elizabeth the bitch does. We're going to talk about some court cases that talk about race. And we've kind of talked about them a little bit here. But the court cases talk about race are used to talk about what was once considered subjects. Because of the so-called 14th Amendment, all subjects became U.S. citizens. And I want to stress again that race has nothing to do with this. This has everything to do with its corporate law, and I don't care what race you are, you can be a sovereign. Matter of fact, we'll talk about that more. Anyways, in the Chisholm versus Georgia case, it says, but they are sovereigns without subjects, unless the African slaves among us may be so called. And it's the U.S. Supreme Court. This is an 1854 court case. No black or mulatto person or Indian shall be allowed to give evidence in favor of or against a white man. The words Indian, Negro, black, white are generic terms designating race. Therefore, Chinese and other people not white are included in the prohibition from being witnesses against whites. Excluding Chinese witnesses in suits to which white persons are parties is affirmed. And the indicium of color is not an infallible test to the competency of a witness under the Act excluding blacks, mulattoes, and Indians from testifying for or against white persons. In a criminal action against a white person, a black or mulatto person, though the injured party cannot, under a statute, be a witness against the defendant. The words in favor of or against any white person in the Act prohibiting persons of one half or more Indian blood or Mongolian or Chinese from giving evidence refer to the defendant alone in a criminal action. Okay, so what these cases are basically saying is that it's talking about these other races before the 14th Amendment. They were citizen subjects, and after the 14th Amendment, they became U.S. citizens. The 14th Amendment to the Constitution of the United States does not conflict with the power of the legislature in the exercise of its discretion to exclude Chinamen from the right to testify in state courts. The evidence of a Chinaman cannot be admitted to provide a white man guilty of manslaughter. The right of trial by jury in civil cases guaranteed by the 7th Amendment. Okay, so now this is talking about subjects, okay? And this is talking about, it's all Admiralty, it's all Roman civil law, and again, the way you get subject to this is they get you in a contract. Anyways, the right, and it's all coming from the Vatican. I got to tell you, it's these bar members that are doing it. Anyways, the right of trial by jury in civil cases guaranteed by the 7th Amendment and the right to bear arms guaranteed by the 2nd Amendment have been distinctly held not to be privileges and immunities as citizens of the United States guaranteed by the 14th Amendment against abridgment by the states. And in effect, the same decision was made in respect to the guarantee against prosecution except by indictment of a grand jury contained in the 5th Amendment and in respect to the right to be confronted with witnesses contained in the 6th Amendment. Okay, so again, that's the U.S. Supreme Court said U.S. citizens don't have access to the first 8 amendments to the Constitution against the powers of the federal government. And so they're basically saying the same thing in this case. The technical niceties of the common law are not regarded. A jury does not figure ordinarily in a trial of an admiralty suit. The verdict of a jury merely advisory and may be disregarded by the court. The rules of practice may be altered whenever found to be inconvenient or likely to embarrass the business of the court. In other words, we want to railroad this guy, and so we'll just bend the rules here a little bit. A court of admiralty acts upon equitable principles. A libel of information accusation does not require all the technical position of an indictment at common law. If the allegations describe the offense, that is all that is necessary. Is founded upon a statute is sufficient if it pursues the words of the law. And this is talking about admiralty and these equitable courts, these kangaroo courts, these UN courts that you see operating these days. U.S. Constitution, Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. Okay, so a subject is property. Okay, so a U.S. citizen is property. Okay, you're a slave. That's exactly what a U.S. citizen is a slave. But they have to gather evidence against you, and again, it's not about race. It's all about slavery, and it's all about corporate law. There have always been 2 classes of citizens. The citizens of each state shall be entitled to all privileges and immunities as citizens in the several states. Okay, so that's the U.S. Constitution, Article 4, Section 2, Clause 1. And then it goes back to Leviticus, even talks about 2 classes of citizens. But the stranger that dwelleth among you shall be unto you as one born among you, and thou shalt love him as thyself, for you were strangers in the land of Egypt. That's exactly how they enslaved the children of Israel, is they used 2 classes of citizens. Love ye therefore the stranger, for you were strangers in the land of Egypt. Deuteronomy 10 and 9. And the U.S. Supreme Court even uses these terminologies. The rights of sovereignty extend to all persons and things not privileged that are within the territory. They extend to all strangers resident therein, not only to those who are naturalized and to those who are domiciled therein, having taken up their abode with the intention of permanent residence, but also to those whose residence is transitory. All strangers are under the protection of the sovereign while they're within his territory and owe a temporary allegiance in return for that protection. And that's, again, U.S. Supreme Court, and they're using this strangers terminology that's taken right out of the Bible. Strangers have a social security number, a social insurance number, Deuteronomy 23:19-20. Thou shalt not lend upon usury to thy brother, or usury of money, usury of victuals, usury of anything that is lent upon usury. Unto a stranger thou mayest lend upon usury. So they want a social security number so they can verify that you're one of the slaves. You're a stranger. Think about it. The bankers' thieves will not loan their so-called money unless you can prove you're a resident. The dissenting opinion asserts that the 14th Amendment is a part of the Constitution of the United States. While this same assertion has been made by the United States Supreme Court, that court has never held that the amendment was legally adopted. I cannot believe that any court in full possession of its faculties could honestly hold that the amendment was properly approved and adopted. And that's a Utah court case. And so the so-called 14th Amendment, it's a fraud. The so-called 14th Amendment citizen is a corporation as used in this chapter. This is 28 U.S.C. Section 3002. United States is a federal corporation, and any agency, department, commission, board are all entities of this corporation. A U.S. corporate citizen does not have access to the first 8 amendments against the powers of the federal government. The U.S. corporate citizen does not have the right to trial by jury, does not have the right to keep and bear arms, does not have the right to face your accuser, does not have a right to give evidence against state citizens, does not have a right to common law indictment. They use information only. How many times do they do shit with that information? They have mandatory military service, mandatory taxes, may vote, but it doesn't mean anything because there's no political power. And if they do something because of the vote, it's because they feel like doing it. It's not about race. The U.S. versus Amistad is a good example. There was some slaves. The Amistad was a slave vessel, and it had a load of cargo of slaves, and what happened is the slaves overpowered their captors and killed them all except for one, and they said, take us back to Africa, and because they didn't know how to navigate, they didn't know how to sail a ship, and the guy that was that they didn't kill sailed in circles off the coast of Virginia until the U.S. Navy found him, and they brought him back and put him on trial for murder. And so what happened is it went all the way to the Supreme Court. Look it up. That's the Supreme Court citation right there. And what happened is the court finally ruled. Actually, the arguments in the case were either A, if they're slaves, they're property, and therefore they're no different than a dog or a cat, and a dog or a cat can't commit murder. And if they're not slaves, then they're free men, and they had every right to do what they did. And the U.S. Supreme Court said they had every right to do what they did, and they sent them back to Africa. And so again, so it's nothing to do with race. That has absolutely nothing to do with race. It has everything to do with slavery, and they're using this. It's all coming from the bankster thieves and their Jesuit Vatican handlers, and it's all about divide and conquer. And so we cannot allow ourselves to get diverted away from the real issues. When people start talking about race and stuff like that, it has absolutely nothing to do with race, and it has everything to do with slavery. And this is actually a quote from Albert Pike, who was a Confederate general and became, after the Civil War, became a head of the Masons. Okay, and the First World War must be brought about in order to permit the Illuminati to overthrow the power of the Tsars in Russia and making that country a fortress of atheistic communism. The divergences caused by the agent terror of the Illuminati between the British and Germanic empires will be used to foment this war. At the end of the war, communism will be built and used in order to destroy the other governments and in order to weaken the religions. The Second World War must be fomented by taking advantage of the differences between the fascists and the political Zionists. This war must be brought about so that Nazism is destroyed and that political Zionism be strong enough to institute a sovereign state of Israel and Palestine. During the Second World War, the international communism must be strong enough in order to balance Christendom, which would then be restrained and held in check until the time when we would need it for the final social cataclysm. The Third World War must be fomented by taking advantages of the differences caused by the agentur of the Illuminati between the political Zionists and the leaders of the Islamic world. The war must be conducted in such a way that Islam, the Muslim Arabic world, and the political Zionism, the state of Israel, mutually destroy each other. Meanwhile, the other nations, once more divided on this issue, will be constrained to fight to the point of complete physical, moral, spiritual, and economical exhaustion. We must unleash the nihilist and the atheist. We shall provoke a formidable social cataclysm, which in all its horror will show clearly to the nations the effect of absolute atheism, origin of savagery and the most bloody turmoil. And it goes on, it says, then everywhere the citizens obliged to defend themselves against the world minority of revolutionaries will exterminate those destroyers of civilization, and the multitude disillusioned with Christianity, whose deistic spirits will from the moment be without compass or direction, anxious for an ideal, but without knowing where to render its adoration, will receive the true light through the universal manifestation of the pure doctrine of Lucifer, brought finally out in public view. This manifestation will result in the general reactionary movement, which will follow the destruction of Christianity and atheism, both conquered and exterminated at the same time. And so that's what it's all about. It's about Satanism and Luciferian Vatican. That's where it's coming from. And Albert Pike is talking all about it right there. You can be a national without being a citizen. Citizenship is part of the political community. The U.S. passport application even talks about a national, and it says I'm a citizen or non-citizen national. The application form in the instructions talks about non-citizen nationals. It is, however, true that in all common law countries it has always and consistently been held that the wife and minor children take the nationality of the husband and father. That is common law doctrine. In doing this, I shall have occasion, incidentally, to evince how true it is that states and governments were made for man, at the same time how true it is how his creatures and servants at first deceived, next vilified, and at last oppressed their master and maker. Let a state be considered as subordinate to the people, and everything else be subordinate to the state. And is that ever going on today or what? Every citizen and freeman is endowed with certain rights and privileges to enjoy which no written law or statute is required. I don't need some statute. These are the fundamental or natural rights recognized among all free peoples. As a general rule, men have a natural right to do anything which their inclination may suggest, if it be not evil in itself and in no way impairs the rights of others. The law of nature, being coeval with mankind and dictated by God himself, is of course superior in obligation to any other, is binding over all the globe and all countries and at all times. No human laws are of any validity if contrary to this, and such of them as are valid derive all their force and all their authority immediately from this original. And that's Black's Commentaries on the Laws of England, Blackstone's Commentaries on the Laws of England. The acts of the legislature, apparently contrary to natural rights and justice, are in our law and must be in the nature of things considered as void. The laws of nature are the laws of God, whose authority can be superseded by no power on earth. A legislature must not obstruct our obedience to him, from whose punishments they cannot protect us. All human constitutions which contradict God's laws, we are in conscience bound to obey. Bound to disobey. And again, it comes down to the same stuff, okay? If a judge is dealing with a statute, he's not a judge anymore. He's a clerk. And so that has nothing to do with we the people. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. The corporation is an artificial entity which owes its existence to and charter powers to the state, but individuals' rights to life and own property are natural rights for the enjoyment of which an excise cannot be imposed. And this is as old as time itself. This is taken from Acts. And when they bound him with thongs, Paul said unto the centurion that stood by, is it lawful for you to scourge a man who is a Roman and uncondemned? When the centurion heard that, he went and told the chief captain, saying, take heed what thou doest, for this man is a Roman. Then the chief captain came and said unto them, tell me, art thou a Roman? He answered, yea. And the chief captain answered, with a great sum obtained I this freedom. And Paul said, but I was freeborn. Then straightly they departed from him, which should have examined him, and the chief captain was also afraid, after they knew that he was a Roman, because they had bound him. Okay, and so this is as old as time itself. How can you lose your sovereignty? In order for a member of the sovereignty to become subject to regulation in any way, they must agree to it. There's got to be a contract. As with any contract, it must be knowing, willing, and intentional. But individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to their purely personal privileges. Rather, they assume the rights and duties and privileges of the artificial entity or association which they are agents or officers, and they are bound by its obligations. Okay, so that's why they need to fabricate evidence of this corporation. Everything is by consent. This is taken from Section 14 of the Criminal Code of Canada. No person is entitled to consent to have death inflicted upon him. Well, think about it. When they put that in there, everything else is by consent. The rights of individuals are restricted only to the extent that they've been voluntarily surrendered by citizenship to the agencies of government. The state citizen is immune from any and all government attacks and procedure absent contract. Every man is independent of all laws except those prescribed by nature. He's not bound by any institutions formed by his fellow men without his consent. They don't have authority to do that stuff. They don't. That's why a statute means nothing. The rights of individuals are restricted only to the extent that they've been voluntarily surrendered by the citizenship to the agencies of government. This is a letter sent by Arizona Senator Wayne Stump, and in 1985. We're going to get in closer here. This is showing it closer, and it was sent to Ralph Melstred, Director of Public Safety. It's come to my attention that numerous individuals in our state have rescinded all their contracts with the federal government, the state of Arizona, and each of its political subdivisions, establishing themselves as freemen under the organic national constitution of the Republic of the United States of America. Consequently, they may be driving without auto registration, driver's license, and any other evidence of contract. Because many law enforcement personnel may be unaware of the contractual nature of auto registration and driver's licenses, it is conceivable that this situation may lead to confrontation between these individual and law enforcement personnel. I urge you to inform yourself and your personnel about this matter as soon as possible. If you would like to be briefed by someone knowledgeable on this subject, please contact me. In the meantime, inasmuch as this procedure is entirely appropriate when properly carried out, I would like to be personally notified of every such instance of confrontation. So, again, this is how you do it. You rescind the contracts. It's all a fraud. State citizenship is a vested substantial property right, and the state has no power to divest or impair those rights. So how can you lose your sovereignty? Ignorance of the law is no excuse. Anytime you get anything from the government, it's an implied contract and brings you into their jurisdiction. Anytime you register for anything or make application for anything from the government, you're giving them a power of attorney to make legal determinations for you and represent you. You're making them competent in your affairs. You're telling them you're a person. You're converting yourself into a slave. All statutes are written very carefully, and most do not apply to members of the sovereignty. 99% of the time, the government is technically correct. It is not up to the government to tell you that you're a member of the sovereignty. If you have to go to the bureaucrat and say, what does this statute mean? You're basically saying that you are incompetent, okay? And there is no such thing as an incompetent sovereign. The government lawyers make up a statute that properly applies to those entities they have jurisdiction over. The burden is on us to assert our sovereignty. If a member of the sovereignty gets unknowingly involved in something that operates as a contract by which he loses his sovereignty, he's made a mistake of law and fact. There's lots of case law on that. So whose duty is it to protect the Constitution? The courts have ruled that the government is not the protector of the Constitution. If the government is not the protector of the Constitution, then who is? It's not the function of our government to keep the citizen from falling into error. It's the function of the citizen to keep the government from falling into error. That's U.S. Supreme Court. And that's 100% correct. It's up to us. We need to take care of business. The reason we're getting a tyrannical government is because we're asleep at the wheel. How can you lose your sovereignty? It's the people who are supposed to be, it is the people who are supposed to be protecting the Constitution. How do we, the people, protect the Constitution? Well, we protect the Constitution by challenging what the government does through the courts administratively and for refusing to participate. It is one of the fundamental maxims of the common law that ignorance of the law excuses no one. The burden is on the sovereigns to know and understand the law and assert their sovereignty. All contracts must be entered into knowingly, willingly, and intentionally. None of the contracts entered into with the government by which you might lose your sovereignty are willing, intentional, or knowing, and actually all you have to do is bring up the issue, and they don't want to talk about it. Matter of fact, they will never talk about it, because then if they admit that such a thing is going on, they're involved in treason. That's exactly what's going on. The sovereignty of the people is unalienable and imprescriptible. In order to regain your sovereignty, you must assert it. And when you assert your sovereignty in the way that we're going to talk about in asserting your sovereignty, you build a case with evidence that you can use in court at a future date that you should you need to do so. You send all documents by registered mail with the return receipt impossible, because registered mail is kept under lock and key and there's a chain of custody. Government attorneys may turn it over to a bureaucrat who may also respond to a point. Does it matter? Do you know who you are? If the government were to admit that you're right, they'd be admitting to treason, extortion, genocide, and other felonies. The government's attorneys will probably not respond at all. That's the smart thing to do, quite frankly. In order to be a true sovereign, you must be self-reliant. You must not only talk the talk, you must walk the walk. You must be knowledgeable about the law and how it works. You must be prepared to take the initiative in court if necessary. You must make it known and know in certain terms that you're all of the above. It's all about slavery. Has nothing to do with race. A U.S. citizen or a citizen of Canada or a citizen of Australia is a slave. Either you're the king or you're a slave, and there's nothing in between. If you participate in their color of law statutes, then you've agreed to be their slave. It is only involuntary servitude that's not lawful. If a nation expects to be ignorant and free in a state of civilization, it expects what never was and never will be. Nobody said it'd be easy, but it is possible. If tyranny and oppression come to this land, it will be in the guise of fighting a foreign enemy, and ain't that the truth? The business of the journalists is to destroy the truth, to lie outright, to pervert, to vilify, to fawn at the feet of Mammon, to sell his country and his race for his daily bread. You know it, and I know it, and what folly is this toasting an independent press? We are the tools and vassals of rich men behind the scenes. We are jumping jacks. They pull the strings and we dance. Our talents, our possibilities, our lives are all property of other men. We are intellectual prostitutes. And that's John Swinton, former Chief of Staff, New York Times. We can educate ourselves. What can we do? We can educate ourselves so we know when our rights are being violated. We can work with our friends and neighbors to reestablish our common law juries and our common law de jure courts. We can educate our public servants because many of them do not know any more than we do. We can educate other people by circulating this video in any other way possible. We can work with our friends and neighbors to get the United Nations out of America and Canada and anywhere that wants to be free. The United Nations is owned and operated by the bankster thieves and their Vatican handlers. We can educate ourselves about what a common law jury is and what the law of the land is. We can demand a common law jury of our peers. Judgment Day is coming for these United Nations bankster thieves, and I'm looking forward to it. I'm looking forward to seeing some of them do that little dance they do at the end of a common law rope. There are common law courts springing up all over, and these thieves are going to be brought to some real justice, and am I ever looking forward to it? I am glad it's not up to me. We never take the law into our own hands because that makes us worse than they are. There are upcoming events: Color of Law, Fire the United Nations Judicial Whore in Texas, City of Fort Worth Pigs, City of Grand Prairie Pigs, How to Do a Habeas Corpus, Asserting Sovereignty, Fire the United Nations Judicial Whores in America. Copies of these documents can be found at my private group at Yahoo. I have got YouTube videos. If you're watching this, then you'll see my YouTube profile. I've got over 150 videos uploaded, and you can also contact me at that email address. So what's the alternative? That's the alternative. It's live free or die. And that's all there is to it. And I appreciate you taking the time to listen to my little rant today. I hope you got something out of it. And please circulate it around.